Back, you're still watching Power Breakfast right here on Citizen TV. My name is Fred Ndimuli. We're still in studio with Kibe Mungai, Steve Ogola and Rachel Masika, all lawyers. We're discussing law today. Yes, and in the past 1, 2, 3 months, we've become lawyers in Kenya. We know a few, like I know, obiter dictum. But let's look at this final day of this window through which you can file a petition against the repeat presidential election. Because either way, whatever happens, whatever the Supreme Court pronounces, however the Supreme Court pronounces itself at the end of this process will matter, whichever way the judgment goes. There are so many questions that we're still asking with regard to what has happened in the electioneering period. People need clarity. Now, let's take a look at some of these issues that will come up. Issues to do with the withdrawal of a candidate. Issues to do with when you order a repeat election, what happens, how is the process? What happens in the case of some constituencies not taking part in the election? These are just some of them, but I'm sure there are others that you may think of that probably you would need clarity on, and this is the only opportunity that we can get this clarity. Like Rachel Masika, what other issues do you think should come up in this process?
Apart from the withdrawal of a candidate, first and foremost, we should know that at the time of that withdrawal, the other election laws had not been passed. Mm-hmm. So at the time of the withdrawal of Raila Amolo Odinga, the only existing law that was supposed to be maybe relied upon should have been maybe the judgment of the Supreme Court of 2013. Mm-hmm. At that time. Then thereafter, a day later, the Ekuru Court case had a ruling a day after. So the issues that will come up in such a petition, if at all it will come, because it hasn't been filed as we speak, should be a subject on that. The effects of the withdrawal at that time. If the impact of the Ekuru Court's case also had any will affect the outcome of the judge's ruling in the subsequent petition, if at all it will be filed. And as we speak of this election petition, I think it's not proper for people to think that it must be from NASA. It can be from any Kenyan. I can walk out of this station and go file it if I feel that actually the election wasn't.
It will cost you. You have to file and deposit some amount, not less than $1 million shillings.
It doesn't matter. There are those who can manage to do it. Yeah, I was just giving an example. Then there's also another issue of other than the withdrawal of Raila Amolo Odinga. There's also an issue of the courts, the first of September order by the court. It really shed light on many things. It wasn't just an nullification as such. There was the issue of compliance. So the issues that will come up in the petition will actually also measure on the compliance, maybe on the part of IEBC, because as we all know, the ruling was not against Uhuru Kenyatta as a president. It majorly was on the IEBC as an institution to ensure that they do another repeat of elections in compliance with the laws. Yes. So did they fully comply? If they did, then well and fine, the Supreme Court will make its judgment. The issue will only be if either of the parties will be able to accept the outcome of the repeat. Yeah.
When I give it, Mungai, what else do you expect should come up? I'm sure you have questions with regard to the process we've been through. This is the time. I don't, you've not indicated that you're filing a petition, but I'm sure you must be hoping whoever files a petition, I hope they ask this question. Which is that question?
I think for me, the biggest question in this election is going to be the issue of nominations. Nominations, I don't know what would be the take of this particular Supreme Court on the 2013 decision that allowed, and something that was being relied upon by NASA, to withdraw. Yes. And that is what will make or break what the outcome of these elections. Because on a plain reading of the Constitution, which is what I subscribe to, there ought to be nominations. But again, if a whole Supreme Court reads that same law to say there will be no nominations, it is relied upon by Honorable Raila Odinga. The following day, the High Court says that was obiter. Then there is that uncertainty. And therefore, the big questions of nominations is one that would require to be resolved. And that would be important, not just for these elections, but even going forward into the future. Because remember, it is on account of the issues of the nomination, and now I go to the issue that would have been important, was I the one doing the petition for them, that may not be there. And the question would be this. If this election, because of originally it was supposed to be two candidates, one was not actually campaigning and actually pulled out about, was it 10 days to go or something like that? Now everybody else actually came into these elections less than a fortnight. These are guys who had no agents,
they did not even print a poster
quite
for
candidates.
the presidential election,
So one would, the big question that I would have raised.
And it could be argued that,
of an election
that it was disadvantageous to those candidates coming. There should have been an indication that you are in the race.
Yes, that would be a big issue. But again, the other issues from the, but I don't see that one coming in.
But it would be nice to get that clarity, if at all you're told.
Precisely, was it to be there?
Yes.
Yes, but because at the end of the day, and that actually this is what explains the lack of big quorum as we expected, turnout, I mean.
Yeah, turnout, yes.
Yeah, that if it was a one-man race, ordinary records are not broken when you are told, go and run a marathon alone. You are likely to break a record if there is Benisa behind you, and panting to try to overtake you. And therefore, this would have been a big issue, so that in many ways, the order of the Supreme Court ended up being an anticlimax. The anticlimax is the one that you see it in the low turnout. The anticlimax is what you see in these new movements that are being created, and I don't know where they are going to take this country. So I want to see what is the contribution of the Supreme Court into all this. But again, on Parliament, even the other conversation, and I hope the Supreme Court is going to make this point. I think in one of the open court, Justice Chacha Mwita of the High Court actually observed it, that probably the issue why courts have had to play such a major role in this set of elections is because court decisions, as opposed to written law, have determined the decisions and have been the guiding factor. Ordinarily, and the Constitution expects that it is Parliament that is going to enact written law, so that moving on into the future, you do not now ask what is it that, what are the judges saying we are supposed to do. It ought to be, what does the law provides we are supposed to do. And I hope they will tell Parliament that moving forward you need to make proper
The other big issue that probably would come up is the fact that not all constituencies took part in the in the election. You expect that question plus any other you expect?
I think, Fred, first of all, what I expect from the political class, from NASA and Jubilee, because of late they've been behaving as if they are immune to the legal processes and the Constitution, and that they can easily veer off and operate outside the Constitution at will and come back and operate within the Constitution. And it's only you and I that is not allowed to veer outside the Constitution. So I believe that they recognize the bindingness of the Supreme Court judgment. That must be recognized. And Kenyans must be ready to find ways to innovate outside NASA and Jubilee to preserve the outcome of that judgment. If the Supreme Court says we have assessed the election, we are of the view that the election was credible, it met the threshold under the Constitution, it is not open to anyone, not open to NASA.
It should be binding.
To think that the old judges have made this decision because they've been intimidated. If the court thinks that this judgment, that this election was a mere mechanical exercise just to have a technical compliance within the 60 days, and therefore proceeds to nullify, I think Jubilee also must be cautious not to delegitimize that court. And if any party that, you know, because of the adversarial nature of this litigation, one person will certainly walk out smiling. That's for sure. In 14 days, if it's filed today, one person will walk out smiling, and the other person, we hope, will also be, while the winner must be magnanimous in victory, because it's a victory for Kenyans,
yes,
and for a victory for common sense, not a victory for an individual party or whatever. Kenyans, let me tell you, Fred, we don't really have a problem whether the presidency is with Uhuru Kenyatta or Raila Odinga, because as I already said, this presidency that we care deeply about, the powers there have been dispersed effectively, and we can have other ways of inclusion. So with that understanding, I would like to invite Kenyans to find an alternative pathway of defending and safeguarding the Constitution. Mm-hmm. We can no longer rely on Jubilee and NASA to deliver that. There's a possibility that they may not. Yes. Now, on the critical issues, what I can expect, I think the court will address its mind to the issues framed. I hope the framers of those issues or the promoters of that petition will capture. I know one of the most obvious things was the confusion in terms of a gazettement. Mm-hmm. He saw Jirongo, his name being in the ballot papers before he was gazetted. And then the second issue, the withdrawal of Raila. Actually, that would be the key plank in this petition, because the way it was discussed was not satisfactory at all. And in a formal setting, the court must satisfy itself that Raila's withdrawal was in fact inconsequential, the way IBC promotes it. Mm-hmm. Because if Raila withdrew on the 10th of October, now as a purely legal question, leave alone the politics, 10th of October, the judgment in place was the 2013 Supreme Court decision. Mm-hmm. At paragraph 290, it says, if there are two candidates, because remember on 5th of September, IBC had gazetted Uhuru and Raila. Mm-hmm. In compliance or in faithful implementation of the 2013 decision. Yes. IBC relied on the 2013 decision to gazette Uhuru and Raila. There were only two candidates by the time Raila was withdrawing. Yes. And the Uhuru judgment had not been delivered. IBC chose a safer route of mark timing, because they knew the next day on 11th of October, the Justice Matif was going to deliver a ruling on the Uhuru case. Then they said, let's wait and process this together. That may turn out to be a fatal mistake that may deny Uhuru the presidency. If it turns out, and the court is of the view that at the time that Raila was withdrawing, the law in place was the 2013 Supreme Court judgment, which says if a candidate withdraws, the election stands cancelled and fresh nominations to ensue. What it would mean the next day that you have a judgment that includes Uhuru and the others, but the judgment can't settle. Mm-hmm. Because the foundation for which that judgment is supposed to settle, the ground has shifted. So it would mean that judgment is for the future, 2022, but this election stood cancelled. If the IBC must work very hard to maintain the perception that, and it's really a difficult challenge, to maintain the perception that Raila's withdrawal was in fact inconsequential, the way they put it, because of the timing. You get? Yes. One way in which they can do that, and I can help them in framing. Uhuru filed his case. Mm-hmm. Just just immediately after gazettement of Raila and Uhuru. You get? So you could say that by the time Raila was withdrawing, he knew that there was already a matter pending in court whose determination could affect his candidature. If IBC explores that kind of argument, then they shift the timeline back to before 10th of October. It's a dicey argument. The other issue, of course, the issue of the returning officers, being found to have been the appointment to be irregular. I'm sure the matter will be interrogated. Mm-hmm. The question of the voter turnout. Voter turnout, I hope IBC also will do a decent explanation. I didn't find that explanation satisfactory, because personally I'm aware about, and some Kenyans are, about management of election day. The law says an IBC's own manual, they require presiding officers to fill in, and they have a polling day diary. Presiding officers are supposed to key in 9 a.m. voter turnout, 11, 1, 3, 5 p.m. 5 p.m. before you start counting, you close. And then you text the constituency returning officer. The question that the Supreme Court will ask IBC, so was the constituency returning officer collecting this statistical data via SMS for his own amusement or what? Mm-hmm. The constituency returning officer was collecting this. If you have, let's say, Kenyatta constituency, where I vote, had 100 polling stations. All these polling stations send their statistical data via text message. And they did it to the constituency returning officer. Compiling them can take just an hour, you send to Nairobi. So it's not true that IBC needed to wait more than 6 hours to get the actual voter turnout. What Chebukati was saying about the logs, at the end, that was the second level of transmitting voter turnout. At the end of the counting and announcement of results, as you send electronically, there was a dialog box there, which IBC was calling the log. You key in the figure that you sent via text message. Now you key in there and now you send to the National Tallying Center. If IBC is unable to explain how they can issue a provisional voter turnout,
they will only explain if these issues are raised before the Supreme Court.
Yes, if it is raised, you can be sure anybody going to court.
But I'm asking because the lobby group, We the People, so far is the one that's indicated that they're going to file this petition. Don't you think we run the risk of missing an opportunity to ask all these questions if at all they are not addressed in this petition by We the People? Don't you think that probably this is where the Law Society should come in, that legal minds come together and come up with questions to present before the Supreme Court?
LSK can't come in and start reframing questions which are not before the court, because if they are coming in,
but
they can come.
If you come in as amicus curiae, you're allowed to.
Amicus, if you want to frame issues, you file your own petition.
That was the old problem. That's how we landed into this.
So
amicus going to ask questions
that
cannot be resolved.
Because the question is, who will ask these questions that need to be clarified if at all this petition does not address?
Let's just clarify this. The petition need not address everything, and the court need not to apply itself. In fact, the court is not allowed to apply its mind to things that are not before it.
Yes.
So we will assume the legal assumption is that...
But we need these questions to be asked.
No, but if nobody raises them, then we can assume illegally.
Then we're missing an opportunity because
we don't need... They'll be asked another day. We don't need to force questions to be asked.
Don't you think?
But it's still early in the morning. Maybe they are learning from what counsel is saying.
Yeah. So they can ask those questions.
But Fred, I think the point we shouldn't lose is this. The beneficial aspect of filing a presidential election petition, both to IBC, to the country, and the parties. To Jubilee particularly, if it's able to emerge victorious, and I pray that Jubilee does not neglect the manner in which IBC responds, because this election, if it is nullified, it will be thanks to IBC. Uhuru Kenyatta has nothing to do with this nullification, neither does Jubilee, unless someone demonstrates evidence that connects Jubilee directly. So, if this court validates the election, I think Uhuru Kenyatta now he had that political legitimacy, legal legitimacy, and he's happy to govern. And NASA will be significantly their claim, their legitimacy will be significantly deflated, because now people will be talking about the rule of law. The court has spoken. You went to court now, so I think that is the stake for Jubilee. For NASA, if NASA manages, because Kenyans, we have not taken leave of our common sense. We know for sure if any lobby goes to court, NASA will certainly be taking a sharp interest in that, because they are likely to benefit from that outcome, or that outcome is likely to harm them, their interest, the political posturing.
Yes.
For the rest of IBC, it's an opportunity for the court to again assess the level of compliance. Remember, the Supreme Court said three things. In my analysis of that judgment, they are happy to excuse anything, but they will not excuse competence, openness, and compliance. Compliance with the law. Did IBC comply every step of the way? Openness. Did IBC communicate?
Yes. And this questions, Bonakibe Mungai, because they're quite a number. You're saying that unless they're addressed in this particular petition by We the People, they are yet to file, that no other person, and not even the LSK, could come up even as amicus and actually try to get clarity, because we rarely get to see the Supreme Court sit on such matters. Yes. By the time we get another opportunity to get them to sit and address this particular process, you strike when the iron is still hot. Don't you think that we'll be missing an opportunity if these questions are not asked now?
Probably you can only wish they were, but as he has said,
you're saying the legal profession does not have...
No. You see, the legal profession, you go to court not on your own behalf, unless in a case you have decided you are the petitioner or you are the applicant. But in a case where an individual has brought you to court, has taken a matter to court, you can only suggest that this is also an important issue, should be included. And many times, lawyers would include important issue in their own perspective. Now, that might happen. We hope there will be, as if it is filed, that there would be a serious petitions that helps to get clarity. But my caution still remains that petitions, and for now, moving to the future, expecting that the courts are going to provide solution to what appears to be legal gaps, because what we are really talking about are gaps in the law. It is not the business of the court to legislate. The business of the court is to interpret and apply the law. which has already
so
been
instead
enacted.
Instead of presenting to court, we go back to Parliament.
Precisely. The first business of this Parliament, and I hope this is not going to be a process that is going to be led by the legal committee and the majority leader on Abotuale. We now need to have a truly professional way in which we are able to get these issues of determination of the issue of how many days can you do an elections? Because, for example, under the Constitution, you heard Uhuru Kenyatta was saying, we ought to have had a recount of the votes. It would have confirmed that I won. The Elections Act as it exists today, you can actually be able to say, I'm happy with the votes I got in Siaya or Kasipul Kabondo.
Yes.
But I have questions about the votes you claim you got in Roiro.
Yes.
And that you got somewhere in Moiben. Now, within 14 days, these important questions cannot be resolved. And therefore, for me, moving forward, one of the important reforms that needs to be there is to ensure that in future, when petitions are determined, it is on the basis of substantive justice. Because the dissatisfactions and substantive justice, for example, would be, you have said you are happy with how people voted in Siaya and Mombasa. You only have Kiambu. But Kiambu, we can get the courts to count whether the votes that are claims to have been obtained in Kiambu are in fact, that is the truth. And you see, the only way to do that, it is not something that can be done within 14 days. So, and that's why I'm saying that moving forward, the country must engage in reforms and the business of politicians, because they are the cause of this mess. Even when they were asked very late in the day that if you had any legal advice by any lawyer telling you that you can have a serious petition heard within 14 days, that was a terrible lawyer. There is no country in which you expect any serious business to be conducted within 14 days.
Okay.
And therefore, that's why I'm saying that moving forward, let's have some respect for people who understand what they are doing.
Okay.
Because you do something, then next time you say, you're dissatisfied.
And it's time for us to wrap up this discussion. I'll give you a chance to say something, but on this issue, I want your, I want your argument or interpretation of this matter. The amendments to the election laws that President Kenyatta said that he did not sign them, but the time lapsed. They were gazetted last week. In the next 10 days or 11 days, they automatically become law. It will still be within that window where the Supreme Court will be handling this matter, whichever matter comes before them, because it will happen before the 20th, and the 20th is the last day that the Supreme Court has. Does it mean that those amendments will not apply? Because Kenyans have been made to believe that Jubilee was rushing through those amendments so that they could affect the process going forward. Now that this has happened the way it has, do you think, and this is your own interpretation, different lawyers interpret it, it's like pastors interpreting the Bible, do you think those laws will apply in this case? In this particular petition, if it's filed today?
Personally, I don't think those laws should apply. Because the 1st of September ruling by the Supreme Court was done in accordance to the existing laws at that time. So in that, the election that was to come in the 60 days was supposed to be subjected to the compliance of the laws at that time.
As at the time that the Supreme Court made the judgment?
Made the judgment.
Okay. Well, Steve?
Well, as Rachel says, those laws can't apply, and if somebody tries to cite them, of course the judges will not look at them, because they are not used in this election, and the parameters for assessing the election would not rely on them. And even for the future, some of them are problematic, and I see later on someone challenging some provisions, like the ones that seeks to reassign constitutional duties of the IBC chairperson to another person, unless the constitution is amended. We said before that is one of those obvious unconstitutional provisions. But having said that, I think going forward, it's very important for Kenyans to know that the judicial process will not give us a harmonious approach as a country where we're going, because it will be hotly contested. You can expect Jubilee to defend that their win in this October 26th election. You can expect us to continue delegitimizing that way and the election. So it will leave us even more sharply divided. And I'm afraid that this time the Supreme Court may even be more susceptible to delegitimization, But I pray that they continue to take heart and courage. Their fidelity is to the law and the constitution, and they should do the right thing. If they believe there's evidence to nullify, let them nullify, if only to protect their legacy, because it's a court that has shown that it's independent, and also to advance the rule of law, and also to create opportunity for people to keep on going to court. The perception that the Supreme Court is now under some kind of attack, only them can correct that, because they initiated it themselves. Way forward for Uhuru and Ruto and Raila, I would really pray that these leaders meet. Because you see, it was really nice to see them shaking hands in church yesterday. These political problems, I'm sure it's not about, Raila has said it many times, it's not about him being the president of this country. And you see, if you look at how Uhuru ascended the political negotiation in the G7, it was widely reported that Uhuru was a reluctant candidate and was just pushed there to be. So I don't think he cares for the president so much as to cause people to lose life and to be unable to reach out. What we must be able to, politicians don't usually transition us out of this toxic politics. Yes. They set us against each other with so much talk, but then later on they meet.
It is a political problem.
So we must understand that this country will remain united, will remain forever. You will be embarrassed one day if you keep on fighting for Raila and fighting Uhuru on behalf of Raila. Then you see Uhuru and Raila shaking hands and laughing and smiling. You'll be left there embarrassed, wondering what the hell happened. So I think let them come together. Yes. Preserve the national tranquility. Let there be opportunity for dialogue, reconciliation. As Kibe says, we need now to relook at this constitution and ask ourselves, where does the opportunities for improvement lie? Okay. Do we need to look at that 14-day period? Do we need to amend to give leader of opposition something more tangible in terms of responsibilities? How can
and reforms will come.
Yes, and those reforms we should discuss.
Finally, your final comments on the issue to do with the amendments to the electoral laws, and your final comment as well.
Yes, to the elections law, I think this is not something that we should not be like pastors. We learned in first year in the law faculties that the laws applies from the date of commencement. Yes. Now, when the elections was conducted, it was conducted in accordance with the old law, because this bill had not passed. So that the order of the Supreme Court up to the date of elections was fully complied with. But the relevant part, at the time when this petition, if it is filed, the law would be different, particularly when it comes now to the yardsticks. How do you nullify the elections? Yes. Because before this petition, if it is going to be filed today, there is a law in force that raises the bar on how you can be able to how you can be able to nullify an election. Yes. So that unless somebody challenges the matter before the High Court, and it is heard within 14 days. The Supreme Court, because they are bound to interpret and uphold the law, and they took an oath to defend and to apply that law, they are bound to apply that law that was passed by Parliament. My final comment is this, that much as everybody is saying politicians go and talk and all these, I think we shall need an honest conversations. And this honest conversation, the starting point is going to be two things. Number one, I think there is need for introspections about the political strategy, and this is particularly on the NASA side, that it is good to honestly be able to ask the questions. Why did you lose the elections? Could you genuinely have failed to win power through the elections? Because remember, the Deputy President William Ruto was with them and actually opposed this constitution. But him, in his own political strategy, decided, I'm going to live with this constitution as it is and do my political strategy on the basis of these constitutions. And now, 2022, he could as well become the 5th president of Kenya. Second point is this, that and now that turns to the limits of reforms. Probably it is time, and this honest conversation Kenyans needs to undertake. Is the problem really that we have not done sufficient reforms, or the problems is that to some individuals, until the constitution is tailor-made in a way that gives them the presidency on a silver platter, no constitutions would be good enough. In my view, if that is the challenge, and I believe for me that is a difficulty, that is a political problem. It is a problem that calls for honesty, that would require, I've looked for these things for too long, I don't seem to be getting anywhere, and you leave to the next generations, which might include Amolo Otiende and anybody else, to try and get the presidency for this community. There is no community that has a single bull.
As you
All
said,
communities are expected to have many bulls, so that if one bull cannot sire,
yes,
you must get the next one to do so.
And as you said, it's more of a political problem than a legal one. And we'll leave the politics to politicians. Today, of course, it's back to the court, because that's where we are on the last day of that window in which you can file a petition challenging the repeat presidential election of October 26th. This has been a conversation with Mwanakibi Mungai, Rachel Masika and Steve Ogola, all lawyers of note. And thank you so much, ladies and gentlemen, for your very well considered opinions as we await to see who, when and how that petition will be filed today. Remember, Power Breakfast still continues up until 9 a.m. this morning. Carlos Kiba is still in the house, so do expect some nice country music to come your way in a short while. Willis Raburu and Joy Mudengi also have something lined up. Let's just wait and see what that will be. My name is Freddie Ndimuli. Good morning.